Protesters appeared at Judge Greer's Clearwater home. The FBI arrested a North Carolina man who was charged with putting a $50,000 hit out on some judges who worked on the case. The county commission installed a special computer to handle the hundreds of thousands of hateful emails the court got opposing the judge's ruling. Judge Greer had to withdraw his membership in the Baptist church that he belonged to because they printed stories attacking him. Pinellas voters received postcards asking them whether they suffered from voters' remorse for having re-elected Judge Greer. Other postcards accused him of judicial murder. The judge's home address went up on the internet and dead flowers arrived at his door. Judge Greer was labeled an activist judge. Who is this man? Judge Edward Jones III, born 1955. He's a lawyer, a Republican, appointed by President George W. Bush as a federal judge on the United States District Court for the Middle District of Pennsylvania in February 2002 and unanimously confirmed later that year in July. He is best known for his presiding role in the landmark Kitzmiller versus Dover Area School District case, in which the teaching of intelligent design in public school science classes was ruled to be unconstitutional. After a 6-week trial, Judge Jones issued 139-page findings of fact and a decision in which he ruled that the Dover mandate was unconstitutional. He concluded that ID, intelligent design, is not science, but rather is a religious belief and that had no place in the science classroom. He found ID violated the scientific method by relying upon supernatural explanation for natural phenomenon and therefore lacks testability. To quote from Judge Jones's opinion, quote, "The citizens of the Dover area were poorly served by the members of the board who voted for the ID policy. It is ironic that several of these individuals who so staunchly and proudly touted their religious convictions in public would time and time again lie to cover their tracks and disguise the real purpose behind the ID policy. The breathtaking inanity of the board's decision is evident when considered against the factual backdrop which has now been fully revealed through this trial." After the ruling was handed down, some pundits, such as Bill O'Reilly, Rush Limbaugh, Phyllis Schlafly, Ann Coulter, Sean Hannity, and many others immediately attacked it. Some accused Judge Jones of being a fascist and an activist judge. Jones received death threats, as a result of which he and his family were given round-the-clock federal protection. Judge Jones has a well-worded response to those who level the charge, activist judge. He made the following remarks at Bennington College, where he rejected criticisms that he is a judicial activist, and he explained how judges actually work and how they actually go about deciding cases. Listen, this is Judge Jones. What all of these criticisms had in common was that they omitted to note the role of precedent, how judges work, the rule of law. Trial judges carefully find the facts in a case and apply existing precedent as handed down by higher courts. Most notably in this case, the Dover case, the Supreme Court of the United States. There was simply no attempt in these media criticisms to illuminate those issues or educate the public. In this case, Kitzmiller versus Dover Area Public School District, there were two tests I had to apply. They are the Lemon test and the endorsement test. And what they are, in essence, are carefully crafted tests handed down by the Supreme Court that you overlay against the facts of the case to decide whether or not a particular policy violates the Establishment Clause within the First Amendment of the Constitution. To hear these critics tell it, we live in a world where judges essentially make ad hoc determinations. This is really a false world that they tend to propagate, where judges rule according to personal bias, particular whims, or political philosophies, or in order to please political benefactors, or worse perhaps, respond to the perceived public will at any given time. And that gets into still a larger issue that I think is of somewhat crisis proportions, which I call a crisis in judicial independence. Many judges across the country feel exceedingly threatened by a public, a punditry, and a political establishment that tends to launch ad hominem attacks against individual judges when they disagree with them. If you look at public polls in the United States at any given time, a significant percentage of Americans believe that it is acceptable to teach creationism in public high schools. And that gives rise to an assumption on the part of the public that judges should get with the program and make decisions according to popular will. There's a problem with that. The framers of the Constitution, in their almost infinite wisdom, designed the legislative and executive branches under Articles 1 and 2 to be directly responsive to the public will. They designed the judiciary under Article 3 to be responsive not to the public will, in effect to be a bulwark against public will at any given time, but to be responsible to the Constitution and to the laws of the United States. That distinction, just like the role of precedent, tends to be lost in the analysis of judges' decisions. The one thing I want you to remember, if I leave you with nothing else tonight, is that the rule of law is not a conservative or liberal value. It is assuredly not a Republican or Democratic value either. Rather, it is an American value. The challenge for our time, then, as it relates to the cherished system of justice created by our founders, is to ensure that threats against judges, and by implication to judicial independence, are ratcheted down, and that our independent judiciary is thus preserved. Unquote. Now, he mentioned two tests. He mentioned the Lemon test. Oh, by the way, before we get to the Lemon test, that put Judge Jones as one of Time's most influential individuals in 2006. The bottom row, fourth from the right, is Judge Jones, right there. The Lemon test, 1971, the Supreme Court heard the case of Lemon versus Kurtzman, where the court decided that a Rhode Island law that paid some of the salary of some parochial school teachers was unconstitutional. And here's the test, 3 prongs. First, the statute must have a secular legislative purpose. Second, its principal or primary effect must be one that neither advances nor inhibits religion. And finally, the statute must not foster an executive government entanglement with religion. And the second test he mentioned was the endorsement test. Sandra Day O'Connor gets credit for coming up with this one. A government action is invalid if it creates a perception in the mind of a reasonable observer that the government is either endorsing or disapproving of religion. Now let's talk a little bit about civics. I mean the kind of civics of our American heritage variety. Let's first define a few words. Let's look at the word civic. It's an adjective relating to a citizen, a city, citizenship, or community affairs. Date around 1656. The word civics, with the S as a noun, a social science dealing with the rights and duties of citizens. 1886, give or take. Civil, adjective, of relating to citizens, or relating to the state of its citizenry. Adequate in courtesy and politeness, mannerly, relating to or based on civil law, relating to private rights and to remedies sought by action or suit, distinction from criminal proceedings. Date around the 14th century. And a new word, civication. Noun, the art of promoting civics education and civil responsibility. Date, 21st century. Okay, now that we've defined a few words, how many people here believe they can pass a quick civics test? Show of hands, please. Show of hands.